Social workers have a central role within the local authorities with a duty to promote, support, and safeguard the well-being of all children in need in their area, insofar as is consistent with that duty to promote the upbringing of children by their families by providing a range and a level of service. Hello, I'm Chris Aniche, the presenter of the program Family Law Nugget. Welcome to today's episode. I'll be explaining in this video when you can appeal a care order. Many clients have asked me, can I appeal a care order made by a judge? The answer is yes. You can appeal against a care order. However, this is on a very limited grounds, which I'll be explaining to you in this video. The procedure for an application to appeal a decision of the lower court is contained within the Family Proceedings Rule 2010, Practice Direction 30. Generally, an appeal against a decision about a child's welfare are difficult to challenge if they are found on a point of law or that the lower court got it wrong by the conclusion that the court reached in making that decision. In deciding the issues of surrounding the children's welfare, the court is merely exercising what we call a discretion between two or more reasonable options for a child. It will be difficult to demonstrate that the lower court got it wrong for choosing one option against the other, most especially when the case is a finely balanced case. You can appeal for a limited reason, that is, where the court got the facts or the law wrong, but they are hardly successful. Please note, if you're going to embark upon an appeal, you will have to be very careful to identify what the judge got wrong, rather than just simply saying that you do not agree with what the judge did or what the judge said or the conclusion. So now the grounds of appeal. The test for whether the permission to appeal should be granted is whether what we call there is a reasonable prospect of success or some other compelling reason as to why permission should be granted. This is under Rule 33 of the Family Law Procedure Rules 2010. And the prospect of success means that one, there is a realistic rather than what we call a fanciful, not one which has a greater than 50-50 chance of success. You will only succeed to appeal the decision if the judge was wrong or if the decision was unjust due to what we call a serious procedural or other irregularity in the court below. Also, please note, except directed otherwise, an appeal would not stop or stay the order of the lower court. Now, coming to time limits. If you intend to appeal, there are very strict time limit or deadlines for making the appeal. But first, you will need to ask for what we call a permission from that court, a permission to appeal, before any judge will hear your further arguments about the actual appeal you are making or you intend to make. There is a strict time limit of 21 days. This is under Rule 30.4 sub 2. There are several other steps that must be taken, for example, to lodge your appeal, which I will be discussing now. The first one is you need to lodge an appellant notice with the court you are appealing against their judgment, which will be the county court, or for example, it might be the principal registrar of the family division where the decision was made. And this has to be within 21 days of the first decision. You will have to file the following document in support of your application. 2 additional copies of what we call the appellant notice. Number 2, 1 copy of the appellant notice for each of the respondents. 3, 1 copy of the appellant's skeletal argument for each copy for each of the appellants. Number 4, a sealed or a stamped copy of the order being appealed, or a copy of the notice of making the order. Number 5, a copy of any order giving or refusing permission to appeal, together with a copy of the court's reason for allowing or refusing your permission to appeal. 6, any witness statement or affidavit in support of any application included in the appellant's notice. You must also file an appeal bundle, which would need to include number 1, a sealed or a stamped copy of the appellant notice. 2, a sealed or stamped copy of the order being appealed against, or a copy of the notice of making that order. Number 3, an affidavit or a witness statement filed in support of any application, which will be included in the appellant's notice. Number 4, where the appeal is against a consent order, a statement setting out the change in circumstances since the order was agreed, or other circumstances justifying a review or a rehearing. Number 5, you have the option of including a copy of the appellant's skeletal argument. A skeletal argument, this is a written document where you set out why you think the decision of the court should be overturned. This is your argument. It is best to try to be as concise as you can and write it in numbered paragraphs. So that is you setting it out properly. Then number 6, the written reasons for the magistrate who made the decision, the written reasons, their decisions. Number 7, the application form should also be included. Number 8, the application notice or any case management documentation, which will be relevant to that particular application, your appeal process. Number 9, any other document which you, the appellant, reasonably considers that it's necessary to enable the appeal court to reach a decision on the application that you have made. Also, number 10, there might also be some other documents which you think is important with respect to your application. And finally, you must then serve all these documents on all the parties within 7 days of serving these documents on the court. You need to serve it on the parties. I hope I've been able to explain some of the processes with respect to appeal. I must warn you that the procedures are quite complex, so it is better to seek the advice of a solicitor who will be able to tell you and explain and advise you the proper procedures. Thank you very much for listening to this video. Like and subscribe. Thank you very much, and my name is Christopher Aniche. Look forward to you watching our future videos. Thank you very much. Bye-bye.